All right, welcome back, everybody. Thanks again for coming and listening to us today. My name is Jessica Moore, and I'm a student education rights attorney here at Abdenor Weicker. I practice in Ohio in a variety of education-related matters, so student discipline, K-12, suspension, expulsion, specifically Title IX in both the K-12 and higher education realm, bullying, higher education code of conduct and academic misconduct matters, and a variety of other matters. So I want to briefly start by saying that Mark Weicker gave a great presentation at our conference last year on a general overview of Title IX, the new 2024 regulations, and what those changes were, and briefly covered the formal complaint process. This is really a continuation of that. So we're going to really focus on the Title IX investigation process today. But for those of you who did not attend last year, I do want to cover some of those introductory points. I don't know why the slides are not moving. Let's see. Let me stop sharing real quick and see if I can figure it out. Mark, I know you unmuted, so I didn't know if you had ideas.
Oh, yeah, you're just trying to advance the slides.
Mm-hmm.
Let's see, can you see your window with the slides?
Well, I just stopped sharing my screen, so
I mean, can you see it on your own display though?
yeah, I can.
Because you'll have to move to that window to advance. So, yeah, go ahead and share it again.
Let me see. It worked this morning, so I'm not quite sure. I apologize, everybody.
Oh, we'll get it worked out. That's okay.
Okay.
It is coming. There it goes. Go to if you start the show.
Mm-hmm.
Now, do you have a separate window on your computer that you could where the show is or not?
No, I do not have that.
You don't.
No.
Um,
Okay, let me see. It seems to be working now. So maybe I just had to go out and do it again. Okay.
No, okay. Advance a couple and then come back just to be sure.
Yep.
Okay, yeah, that's working.
Perfect. Okay, I apologize, everybody. I promise it was working this morning. So, getting back, before we talk about the Title IX investigation process, it's important to talk about what Title IX is. So, when we talk about Title IX, we're talking about Title IX of the Education Amendments of 1972. And what that states is that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity, receiving federal financial assistance. So one thing that I will note here is that you will see a lot today, the word recipient in the presentation. That essentially is going to refer to that entity receiving that federal financial assistance. So just be on the lookout for that. I may say school or college or university, but just know that is referring to only those that are receiving that federal financial assistance. So when we talk about Title IX, we also have to talk about the Title IX regulations, because the regulations really lay out the policies and procedures that these schools have to follow. And so talking about the Title IX regulations, there have been some important changes even since we did our presentations last year. So just a little bit of that history. So in August of 2020, we had the Trump era 2020 regulations that went into effect. In August of 2024, under the Biden administration, we had these new regulations that Mark talked about last year that really had several changes and very key changes to the Title IX regulations. However, this past January, federal district court issued a decision essentially vacating the 2024 regulations. which essentially made these 2024 regulations non-applicable anywhere, right? So what this means is that as of today, we are in every state currently back to those 2020 regulations. So everything that Mark talked about last year in terms of what the new regulations were are not in effect anymore. So Title IX covers a lot of things. It can cover disparate treatment on the basis of sex, but it also includes sexual harassment. And so for the purposes of this presentation today, we are going to be focused on sexual harassment and those investigations. And so what is sexual harassment under Title IX? Well, it's conduct that on the basis of sex satisfies one of the following. So the first is quid pro quo harassment. And what that is where an employee of the school essentially conditions the provision of an aid, benefit, or service of that recipient on an individual's participation in unwelcome sexual conduct. So one example of this is perhaps a college professor telling a student, hey, I will give you an A if you sleep with me. That's an example of quid pro quo harassment. The second category that it could fall under is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive, so you need 3, that it effectively denies a person equal access to the recipient's education program or activity. Or lastly, if it falls under sexual assault, dating violence, domestic violence, or stalking. So, actually, let me go. Yes. So Mark talked about this a little bit last year, but I want to go over it again because before we talk about investigations, we have to talk about how we get to an investigation, right? And so the start of a Title IX investigation is a formal complaint. And a formal complaint is essentially a document either filed by the complainant or signed by the Title IX coordinator alleging sexual harassment against a respondent and essentially requesting that the school investigate those allegations. Once that formal complaint is filed, the school has to follow a grievance process that complies with the regulations. And so we're going to talk about what those requirements are and what schools have to have in their grievance policies in a second. Now, schools can have additional rules and policies in addition to what's required under Title IX. However, they have to be consistent with the regulations and they have to be applied equally to both the complainant and the respondent. So there's a number of pieces that schools have to have included in their grievance process. And so we have those listed and we'll talk about them individually. So the first is that you have to treat complainants and respondents equally, right? So anything that applies to one has to apply to the other. It requires an objective evaluation of all relevant evidence and provide that credibility determinations cannot be based on a person's status as either a complainant or a respondent. You have to require that the Title IX coordinator, investigator, or decision maker not have a conflict of interest or bias. And that's a bias for or against complainants or respondents in general, or that specific individual complainant or respondent in the case. You have to include a presumption that the respondent is not responsible for the alleged conduct until that determination of responsibility is made, whether it is after a formal hearing in a higher education setting, or if you're in a K-12 setting, after the decision maker makes that decision. The grievance process has to include reasonably prompt timeframes for the conclusion of the grievance process. It does not state what that timeframe must be. There are certain time limitations that we are going to talk about today, but as for when the process has to be done, the regulations do not specify a timeframe. And I will tell you, schools, when they're writing these policies, they, I think, try to provide some reasonable time frame. However, they always give themselves wiggle room. So they will say something like, we aim to complete this entire process in X amount of days. However, we can extend this timeline if necessary. And frankly, it is based on every case, right? How many parties and witnesses are involved, the number of allegations, the availability. Sometimes, with the smaller universities, folks may not be working during the summer, and so that can help the process. but they always will give themselves some wiggle room in their policies. So schools have to either describe the range or list the possible disciplinary sanctions and remedies that could be implemented if the respondent is found responsible. So that is important because a respondent needs to know what is potentially on the table if there is a finding against them. The school has to decide in their policy whether or not the burden of proof is that preponderance of the evidence standard or the clear and convincing evidence standard. So in the Title IX regulations, schools do have a choice between these two standards of proof. The preponderance of the evidence standard is that lower standard. That means, is it more likely than not that the respondent violated that policy? The clear and convincing evidence standard requires a higher level of certainty, but not nearly as high as that beyond a reasonable doubt that we see in criminal cases. So a school has to pick one and essentially list that out in their policy. In my practice, I typically see that preponderance of the evidence standard, but again, it's possible that the clear and convincing evidence standard can be used. A school has to include in their policy procedures and the permissible bases to appeal. So this has to be very clearly outlined for the parties. They also have to describe the range of supportive measures available. So I want to talk about supportive measures for a second. So the supportive measures that a school can offer have to be potentially given to both parties. So they have to be offered to both parties. Both parties do have the right to take advantage of these supportive measures. And this can look anything from, no contact orders to changing of classes. If you're a complainant and, a respondent's in one or two of your classes, you can request that those classes be changed, even if it's outside of, the deadline to switch classes in a college setting. You can have supportive measures that may try to help limit the distance between you in terms of who can go where and when. So if it's a very small college and, for example, and this applies in K-12 settings too, by the way, but if you're in a college, for example, and you have one gym, right? There's only one gym to work out. You both parties are, avid gym goers. The school could, limit who can go and when. They have to make it equal. They have to give both parties equal opportunities to go, but they could, try to change the schedule so the parties are not going to this gym at the same time. One important note about supportive measures is that supportive measures cannot be punitive. So a school could not impose a supportive measure that is deemed a punishment to the respondent, because again, there is this presumption that the respondent is not responsible for the alleged conduct until after the determination is made, right? And so that makes sense. Supportive measures cannot be punitive in nature. And lastly, schools' policies cannot require, allow, or rely on, or use questions or evidence that would seek disclosure of information protected under a legally recognized privilege unless the person holding that privilege has waived it. One example of that can illustrate this is medical records, right? So medical records are protected under law unless the person that holds those records gives permission for those to be disclosed. And so, for example, if a complainant were to have gone to a doctor and have sought treatment, a respondent or the school could not use or access those records without the complainant giving that permission. Okay, so the first step, so we have the policy, we have what schools are required to have in their policy, and we have a formal complaint. So what happens next once that formal complaint is filed? So once that formal complaint is filed, a school has to provide the following written notice to the parties. So there has to be notice of the school's grievance process, including any informal resolution process that the parties could enter into. We'll talk about that in a second. This is typically just, you get a paper, typically it's 1 to 2 pages with the allegations, and then you just have the school's grievance policy just attached to the back. But the school has to give the parties that grievance process in detail. There also has to be notice of the specific allegations of sexual harassment with sufficient detail known at the time. Remember, this is prior to the investigation really starting. So it typically is limited to what is included in the complaint, but the notice has to inform the parties of what the allegations are. Now, I have seen in practice, I have seen this be very short. Again, it's going to depend on what largely is in the complaint. However, I've seen schools try to, and do very well at, summarize what the complainant has stated in their complaint. And I have also seen schools just copy and paste word for word everything that the complainant has said. So this can look a little bit different, but either way, the parties have to have that notice of what the allegations are. In that notice, it has to include a statement that the respondent is presumed not responsible for the conduct until the conclusion of the grievance process. And the notice has to inform the parties that they can have an advisor of their choice who may or may not be an attorney, and also that they can inspect and review that evidence. And so this is what the notice of allegations has to hold. So we have a formal complaint, we have the school sending a notice. What happens next, right? In most cases, a school has to investigate the allegations in the complaint. In most cases. Now, parties can opt into the informal resolution process. This presentation is about the investigation, so we're not going to touch on the informal resolution process a ton. But what that is a way for the parties to resolve the matter with essentially an agreement between the two. Or more than two if there are multiple parties, without going through the investigation, potentially a hearing process, right? Because that process can be long, and frankly, it's usually not fun for any party. And so the informal resolution process, if the parties do want to opt into that, can be a way to try to resolve it earlier. Now, it doesn't result in a finding of responsibility, but it can be a way to have the parties agree potentially to certain terms. Usually it involves a stay away order or a no contact order that applies. But that is a way to go. If the parties do not want to opt into that informal resolution process, again, the school typically has to investigate no matter if they want to or not. Now, that being said, there are some instances where a school both has to dismiss either an entire complaint or an allegation within that complaint. And so we'll talk about that. So a formal complaint has to be dismissed. And I say a complaint, it could just be one or two allegations within that complaint, but they have to be dismissed if the conduct alleged does not constitute sexual harassment, even if it's proved. It just does not fall under one of those categories that we talked about. It has to be dismissed if it did not occur in the recipient's education program or activity, or if it did not occur against a person in the United States. Now, a formal complaint may be dismissed where the school has an option to dismiss a complaint or an allegation if at any time a complainant notifies the Title IX coordinator in writing that they would like to withdraw the complaint. So if a complainant says, look, I no longer want to go through this process, and there are very valid reasons why a complainant may choose to do that, the school does have the option to dismiss it. Now, in higher education cases that I have seen schools choose not to dismiss a complaint or even allow a student to go through the informal resolution process if the complainant is a student and the respondents are staff members. So if they're professors or administrators in their program, just because of the that power differential there, I have seen schools not dismiss complaints. A school can dismiss a complaint if the respondent is no longer enrolled or implied by the school. So again, this is not a requirement. I have seen many cases where, the respondents, in a K-12 setting or in a higher education setting, they just are no longer enrolled, right? They leave the school. Or if it is a staff member, if they quit or resign, the school may then say, we are going to go ahead and dismiss it. It sometimes will depend on where they are in the process. right? So if they have already gone through almost the entire process, at that point, they may not dismiss it. But I have seen schools, frankly, I think because the school doesn't have to go through the full Title IX investigation process, they won't. If they don't have to. And so a lot of schools will take advantage of that, but not all. I have also seen cases where a school has really pushed that even when the student was no longer enrolled and the investigation had not started. And lastly, a school can dismiss a complaint if there are specific circumstances that prevent the recipient or the school from gathering evidence sufficient to reach a determination. So this can come up in an example where, let's say you have a complainant who files a complaint and then they don't want to be involved anymore, right? They don't want to be involved. Maybe they were not aware of how long and how difficult the process can be for folks. And so they just decide I don't want to do it anymore. But they don't want to necessarily withdraw their complaint, right? They want the school to still investigate, but they don't want to be any part of it. But let's say their complaint does not give a lot of information. And so in order for the school to make a finding and make a decision, they need more information from that complainant because they don't know potentially who the party is. They don't know who to interview. They don't have witnesses. They don't have names and dates and maybe some of the details of what occurred. They're, without the complainant's participation, they just and this could apply to the respondent too. Maybe both parties choose not to participate. If the school cannot gather the evidence needed to make a determination one way or the other, they may dismiss the complaint. Outside of these circumstances, a school has to investigate a formal complaint of sexual harassment. And one last thing I'll say about that is even if a school does dismiss either an entire complaint or an allegation for any of these reasons, this does not prevent a school from investigating under a general student code of conduct violation, right? So maybe it's not Title IX, but maybe they just look at it under their conduct process. So that is still possible, and we do see that sometimes. So let's talk about the actual investigation itself. And so the Title IX regulations give a lot of requirements that schools have to follow in the investigation itself. So one important thing to note is that the burden of proof and the burden of gathering the evidence needed to make that determination on responsibility rests on the school. It does not rest on the parties. So that is why it is very important for the investigator to ask very detailed questions in an interview, right? Don't just ask yes or no questions. You really want follow-up questions to be asked. We'll talk about, how to handle that if the investigator does not do those things. But that's why it is very important. And again, these investigations can be pretty lengthy because they are trying to gather all of the information needed. It's also important for the investigator to ask the parties if there are any witnesses, and then for the investigator to then talk to those witnesses. That is very important. And lastly, it's very important for the investigator to also ask for any documentation. So medical records, if the complainant's willing to provide them, medical records, screenshots. We see text messages or social media message screenshots all of the time. Those messages, any other documentation that a party can give to either prove or disprove the allegations, the investigator really should be working hard to gather those things. The school has to provide, and this goes along with that, an equal opportunity for the parties to present witnesses and other evidence. So a school, an investigator specifically, cannot just allow one of the parties to provide all of this, and they can't limit, there are some evidence that can be limited, but they cannot otherwise limit a party's ability to provide this evidence. Another important note is that schools cannot restrict the ability of either party to discuss the allegations or to gather and present evidence. This is important. Parties are able to communicate with their witnesses and to gather information potentially from other people and other witnesses to be presented in the investigation. So I see this a lot where in non-Title IX code of conduct investigations and processes, the code of conduct, most of the time will say that these processes are confidential. You cannot otherwise, speak to people. It can be seen as, tampering or what have you. The Title IX regulations do not allow a school to prevent the parties from discussing this. So that is very, very important, and something that can be different in the Title IX realm that may not occur otherwise. The school has to provide the same opportunity of the parties to have others present during a hearing or potentially an interview or any other meeting, including the ability to have an advisor present. So I have seen some schools, again, this is going to vary. Schools are required to allow the parties to have an advisor of their choice present, even if it's an attorney. This is also very different than some code of conduct policies that I've read, where in non-Title IX situations, a school may say, yes, student, you can have an advisor, but they can't be an attorney. Or you can have an advisor, but it can only be someone who's affiliated with the school. That is unfortunately allowed, and some schools do that. In Title IX, it is not allowed. So schools have to allow both parties to have the ability to have an advisor with them, and that advisor can be an attorney. And so that's very important. And these advisors are able to be present at hearings. We'll talk about this a little bit later, their participation directly in hearings, and when that can happen, as well as in interviews. However, while a school has to give the parties this opportunity to have an advisor present, a school can limit the nature and extent of that advisor's participation. So what this typically looks like is advisors can be present, but usually cannot speak. Sometimes we're able to ask procedural questions, but otherwise we have to essentially sit back and try to advise, the advisee behind the scenes. Now, in Title IX hearings, and this is probably for another presentation, in Title IX hearings, only advisors can ask cross-examination questions. So that is when the advisor does have the ability to participate. Outside of that, typically they're not allowed. So again, schools have to allow parties to have that advisor present in hearings and meetings, but they can limit the extent of that participation. But regardless, it has to be provided equally to both parties. So throughout the investigation, the school has to provide both parties with notice of dates, times, locations, participants of hearings, interviews, and other meetings, right? So you have to have that written notice of any meeting, essentially, that is happening in the process, and enough time for the parties to be able to participate. This will also be important, and we're going to talk about this in much more detail in a few minutes, but the school has to provide both parties with an equal opportunity to inspect and review any evidence that's been gathered in the course of that investigation, including the evidence that the recipient is not intending to rely on. And this is important. And the parties then will have the opportunity to respond to that evidence prior to the conclusion of that investigation. And lastly, the school has to then create an investigative report that fairly summarizes all of the relevant evidence gathered and then send to both parties for their review and written response. So we'll talk about that, both of those, frankly, in a second. So responding to the evidence and the investigative report. This is very important. So prior to the completion of the investigative report, and really this comes after the largest part of the investigation is completed, the investigator has interviewed everybody, they've interviewed parties, witnesses, they've received and they've gathered any documentation that exists. And so prior to when they put everything together into a report, the school has to send to each party all of that evidence. And so what does that evidence look like? So I've seen schools do this in one of several different ways. I don't think that there's a wrong answer here, but either way, the parties get the evidence. So what this can look like, I've seen schools send like a Google Drive folder to both parties that has a bunch of different subfolders in it with all of the evidence, interview notes or summaries, sometimes a transcript of interviews, all of the documentation that's shown, and that's everything from the parties and what the witnesses have provided. I've also seen schools kind of create one big document, right? So they essentially convert everything to a PDF. So even some of the screenshots and if there's pictures and all of that, and they combine everything into one big large document. And they just create it as kind of an appendix to that investigative report. I've seen that as well. And I have seen schools create a draft investigative report where they just intend to put everything into one big document. Either way, however it's done, the school has to give both parties all of the evidence in order for them to review and comment on it. And so once the school gives the parties that evidence, the parties then have to be given at least 10 days to submit a written response, which that investigator will then consider prior to the completion of the investigative report. So what this then does is it allows the parties, and there is a poll question on that, so I'll give everybody a chance to answer. But what that does then is it gives the parties an opportunity to comment, object, and we'll talk about kind of what that looks like in a second, any evidence that was given. And then what happens is that the investigator will then take both parties' responses, if they give any, and then incorporate that information into that final investigative report. So if new evidence is submitted, it's included in there. If it's an objection or if it's additional supplemental information, it will be included. And how they do it can look a little bit different. So again, I have seen some schools just attach it to the end, almost as if it were part of the appendix, as part of the evidence that's been provided. And I've seen some schools actually, incorporate those responses into the text of that investigative report. Either way, the parties will have the opportunity to respond, will be given 10 days, and that information gets included in that final investigative report. Then, once that final investigative report is completed, at least 10 days prior to a hearing, if a hearing is required, we'll talk about that in a second, or at another time of determination. So if a hearing is not required, before essentially the case gets sent to a decision maker, the school has to send each party that final investigative report for their review and another opportunity to respond. So essentially what the school has to do is give the parties 2 10-day windows to review and respond to what has been provided in the course of the investigation. Now, I have seen in practice, I've seen a school give a party 3 opportunities to respond. That can sometimes happen where, for example, let's say a school gives the parties this big evidence packet, okay, however it looks. They give this big evidence packet and a party wants to provide additional evidence that maybe they didn't have, and when they initially spoke with the investigator. So they give a lot of new evidence. They're not just objecting, they're not just commenting on what someone else has said, they're actually giving new substantive evidence. In a case like that, the school could give the other parties kind of a second opportunity to review that additional evidence before completing the investigative report. So I've seen that where maybe parties have more than 2 opportunities, but they have to be given at least those 2 10-day windows to respond. And I do want to talk about before moving on, I want to talk about what those responses look like. So these responses can be, one, you don't have to respond. If there's nothing to respond to, you don't have to. But the responses could be as short as 1 page. I have written some myself that were 20 pages, right? It just depends on the amount of information that you have to respond to. And so what is in a, oh my goodness. Sorry, I don't know what happened to my presentation again. Let me figure that out. I apologize, everybody. Sharing the screen. Okay, we will try this again. Let me go through, and I sincerely apologize, everybody. I think it's gonna take a second. I don't know why it's not popping up. Okay, I don't know why it's not popping up, but I will go ahead and continue. Essentially, it was the same slide. What do responses look like? So this is really going to depend on what the investigation uncovered. Okay. And so if you have, and I apologize, if you have an investigator that, for example, isn't great at asking questions, right? Maybe you have a K-12 student who is very nervous and they haven't gone through anything like this before. They're really nervous and they are answering just the question that is asked, right? And it's a yes or a no question. And the investigator doesn't give a lot of follow-up to that, right? The investigator just takes that yes or no and doesn't try to get more information from that student. You may want to provide that additional information in your response, right? To supplement the information that was not otherwise provided. A response is a good opportunity to do that. It's also a good opportunity to correct any information that is incorrect, right? So if an investigator has your interview summary, right? And maybe they've gotten a fact wrong or they've misunderstood something and it's written in a way that is not correct. That is a good way to correct something. It's also a good way to either give evidence or comment on or provide something that contradicts something that someone else has said in an interview. So either a respondent or a witness, right? I've had this before where, part of the allegations were related to behavior in a classroom and a party and a witness, the other party and a witness kind of added to the initial allegations by describing a kind of another incident. And in a response, what you could do is give context about that incident that maybe contradicts what that other person said. So that's also a good opportunity to utilize and have in that review process. And lastly, it's a good opportunity to make objections. So if information is provided that is not relevant or that is not allowed under Title IX. So for example, evidence about a complainant's prior sexual history that doesn't fall under one of the exceptions, you can provide objections to. So the response period is very, very important to have because it gives you the opportunity outside of an initial interview to provide evidence and to try to dispute what the other side is saying. And this is especially important in a case where there is not a hearing. So we'll talk about this in a second, but in a higher education case, the school has to provide for a hearing. That is not the case in a K-12 setting. So in K-12 settings, schools do not have to provide a hearing. And in my experience, they typically don't. And so, having this review and response period is really your last and best chance at making all of your arguments before the decision maker makes that decision. And lastly, and this was, I believe, on my last slide, just a couple matters of, okay, what happens after the investigation is done and what happens after, the review and response periods and once that final investigative report comes to the parties. So what happens next, and I just said this a few minutes ago, is in higher education, the Title IX regulations require that the school, the college or university has a hearing on the matter. And again, in K-12 circumstances, the school does not have to have a hearing. And so many don't, but they can. And so that is essentially the next stage in the process is either a formal hearing or in a K-12 setting, the decision maker, frankly, just making the decision and giving that outcome in writing. And so that is the next stage of the process. After that, and I said this earlier, both parties have the opportunity to appeal. And so, and again, that process that the school gives has to be fully laid out in their grievance process and given to the parties very early on in that notice. And so that is essentially the next stages. The hearing process and the appeal process is enough for an entirely new presentation. So for the sake of time, we're not going to cover that today. But maybe we will do that next year, hint to Mark. But that is all I have. Again, thank you so much, everybody, for your patience in dealing with my technological difficulties. And hopefully you did not hear my dog in the background. But I am happy to answer any questions that anybody has before we break for lunch.
Jess, you did great. I was gonna pop in and give you a 10-minute warning, but you stopped right in time.
Thanks, Danielle.
All right, thanks, Jess. There is a pending question. It looks like Liz is starting to type some answer, but I'd be glad to read the question and also share my thoughts on that one.
I'm typing, but go ahead, Mark. Yeah.
Yeah. Can you share a little bit about how Title IX may or may not intersect with IDEA or ADA for students with disabilities? More specifically, when the student with a disability, such as a CI student, is the respondent. So I gave a presentation on this just recently, and either of you, Liz or Jessica or anyone else for that matter, feel free to chime in. But yeah, so we do really have separate federal laws in that regard. Of course, IDEA applies in the K-12 context, and then the ADA applies in the K-12 and higher education context. So what I would start with in the K-12 context, that IDEA, to the extent that there's an investigation and the individual being investigated or the respondent is subject to sanctions. First of all, through the course of the investigation, the both parties and witnesses, for that matter, should be provided with any accommodations to help them access the process. So that's, if they need, a support person there, which is provided through Title IX anyway. If they need, additional help in understanding the investigative report, whatever accommodations they may need to understand and participate in the Title IX process, those accommodations absolutely must be given. And then, so that's one part. Now, when you get to the sanctioning stage with Title IX, if there's a sanction that applies to the respondent and the respondent has a disability, and that sanction is going to exceed the 10-day out of school threshold, then a manifestation determination has to be held. What is challenging to understand, I think, in a lot of cases where the Title IX process occurs, is that besides the accommodations I mentioned, that if there's no sanction or that's ultimately adopted or recommended by the decision maker in Title IX, then the MDR process doesn't kick in. So you almost have to postpone, the determination as to whether or not there's going to be an MDR until the sanctioning stage or the responsibility stage, once a decision is made and a sanction is recommended. So I would say that, and then I had another thought that just left me, but yeah, that's a couple things in regards to individuals with disabilities and the in Title IX.
Thanks, Mark. Any other questions?
Oh, I know what the thought was now.
Oh, yeah, go ahead.
It was that's true also for suspension expulsion hearings, because again, the reason that is sometimes confusing or confounding for administrators in schools and advocates for that matter is that sometimes the process can take several months. So you're postponing what would otherwise have been a suspension expulsion hearing happening very soon, and statutorily that indicates it's required to happen soon. You're postponing that, including the MDR if there has to be one, until the very end of the Title IX process, because the investigation has to play itself out before you can make any determination in that regard.
And just to add to that too, I have seen schools try to still, and in fact they did in this case, still implement an expulsion before the Title IX investigation even officially started. It was in that initial stage. And we push back, right? Because, the Title IX regulations say that, supportive measures cannot be punitive. And yet here we are. And frankly, that there's this presumption of non-responsibility until after a determination. And yet the school essentially punished the respondent. And so that's something you really have to push back on. Some of, the feedback I've received was, oh, well, it falls under a different category, right? It's disruptive behavior, or it's, any other violation of the code of conduct that's not under Title IX. And you really have to push back and say, well, these allegations are the exact same behavior that you are, alleging in this Title IX case, right? And so you really sometimes do have to push back with schools on that, because they, like Mark said, they do not understand.
No other questions at the moment.
I'll ask a question. I would put it in the Q&A, but I can't. Jessica, what are some of the most common procedural mistakes that you see schools making during Title IX investigations? Or if that's not necessarily a procedural error you see, what areas do you maybe see schools needing more training in Title IX specifically?
Yeah, so I think schools need a lot more training on the entire Title IX process, not necessarily just investigations. I think probably the most violations I see come through the hearing process. But through the investigation itself, and let me think, and Liz, feel free to jump in too, because you do a lot of these cases, but either letting in evidence that they should not let in, not speaking to witnesses. So sometimes throughout the investigation, the investigator will, and this isn't necessarily, I guess, a violation of Title IX, although I think I can make an argument, is the investigator will ask the party, give me witnesses that you want me to talk to. And then, and what would they know, right? Because the investigator needs to know what types of questions to ask, right? And let's say the party gives 5 or 6 witnesses, and you have an investigator who's like, I don't want to talk to 5 or 6 people if they're all going to say the same thing, right? Maybe the information they would provide is the exact same thing, right? And so maybe an investigator chooses not to call, 1 or 2 of those people because they don't want to, get repetitive information. I can see that. And I think in cases, and I've had that in cases, and it wasn't necessary to fight just because the additional people were not necessarily going to give any additional information. However, you really want to pay attention to that, because there could be one thing that one of those witnesses say that makes a big difference. And so even if in general they are providing the same information, again, anything that they say could be helpful. So really pushing on that as much as possible is helpful.
Yeah, I
Liz,
agree
yeah,
with
feel
Jess.
free.
Yeah, I've got a couple thoughts real quick. So I agree with Jess on that. And I also think just because as a former Title IX and current Title IX investigator, just because you think somebody's going to say that same thing doesn't mean they are. That's actually a really important thing, is to interview multiple people who saw or heard the same things, because they might not tell you the same thing. Or if multiple people tell you the same thing, then that helps you assess credibility. So I don't think that they're going to say the same thing is a good reason not to interview somebody. 2 other things I see a lot of issues with: the credibility I just mentioned. I see a lot of errors. So part of assessing a preponderance of the evidence standard, whether it's more likely than not that something happened, is assessing credibility. And I see schools mess that up a lot. Either they don't assess credibility and they'll just throw their hands up and be like, it's a he said, she said, or they will assess credibility wrongly by saying, well, more people said this, so that's more likely than not. I could pay everybody $5 to say what and get 100 people saying what I want to say. You've got to assess whether it's more likely than not that what the person is saying is true. And that can be very difficult. And the credibility assessment might be that you can't determine credibility for whatever reason, but then you need to at least include that in there as a decision maker. The other error that I see a lot is, oh shoot, I forgot what it was. There was something else that I see a lot with respect to, I think it was something with respect to hearings. With hearings, so when you're having a hearing, you should already have an investigative report. The hearing should not be an opportunity to relitigate the case, right? Really, what a hearing ultimately, all it has to be, if you're complying with the law, all it has to be, frankly, is a very short opportunity for each party to cross-examine the other if they wish to. Like, that's it. A Title IX hearing could be 5 minutes long. But I see these hearings where they go through every witness and have everybody talk about everything, and the hearing takes 10 hours or sometimes 2 days. There's absolutely no reason to do that. If you have a competent Title IX investigator handling the investigation, they will put together a report that ultimately gives the fact finder everything they need. And you can just be doing your duty to comply with the law to give the parties the opportunity to cross-examine at the hearing, and that's it. Those were the two things I had.
I agree, Liz. I agree with both of those things. I see those issues a lot, especially the longer hearings, for sure.
Now, there was one question which I answered, but I'd love your input, both of your input on this quickly, as to whether you agree or if there's a clarification needed. It says, what is the evidentiary standard for admissibility of evidence in the investigation stage and at a hearing? I said evidence must be relevant to determining whether the conduct in question occurred or assessing party or witness credibility. This means it tends to prove or disprove any material fact. The investigator shares the evidence they determine relevant and not, and the parties have an opportunity to object before it reaches the decision maker. If you have anything to add to that.
Just add that, I mean, I think that's exactly right, but I would just add that it's a relatively low standard, right? As long as something is arguably relevant, it's going to be allowed unless it's expressly prohibited. So it's a really low standard to meet. And almost, I would say almost virtually anything that's related to the allegations is likely going to be deemed relevant.
Okay, well, I think we're out of time. It's lunchtime. And there's really just one other question in regards to what training should Title IX investigators have. Let's postpone that to the Q&A at the end of the day. We'll save that question. And yeah, we'll break here for lunch and return at 1 o'clock.
Thank you, everybody.
Thank you, Jessica.